had framing issues and drafting pleadings. In March, we had addressing the jury during jury selection and opening and closing. In April, we had direct and cross-examination. This month, we have mediation. And next month, we have creating trial presentations, essentially how to make your trial more vivid with demonstratives and PowerPoint presentations and things like that. Today, I'm filling in as a moderator for Jamie Herron, who I understand is in trial. It sounds like if she's in trial, she didn't settle her case. So maybe she would benefit from attending a MCLE on mediation. We'll have to send this to her after it's done. But speaking of that, being able to send it to her after this is done, all of the Trial Basics series presentations are available online on the Contra Costa County Bar Association website under the self-study. And let me just walk you through how to get there. If you haven't gone to this amazing website, Contra Costa County Bar Association, great website. Go to For Attorneys, MCLE opportunities, scroll down, self-study. And as you see here, here's all the Trial Basics series. You have different ways that you can watch it and download all the materials, things like that. So today we have only a few attendees, which I actually think is really good for MCLE presentations, because people can chime in, ask a lot of questions. We highly encourage that. We want to take all questions. Maybe even if in the beginning, if you want to put in the chat your area of practice, so that the presenters today can maybe focus, and touch on more issues that come up in the line of practice that you're in. We're here to make this as beneficial for you as we can. We are going to go through a number of things like preparing for mediation briefs, how to best use a mediator, negotiation, mediated agreements, things like that. So those are a couple of topics we're going to get into, but we highly encourage if there's something on your mind about mediation, just let us know and we'll try and cover that. If there anything comes up along the way, feel free to chime in. So somebody, in terms of our presenters, somebody had this just ingenious idea that for a mediation presentation that we have mediators come and speak to us. So we have two amazing mediators. We have Lauren Tate, and Lauren Tate has been mediating since 2012 and was actually named the San Francisco Trial Lawyers Association 2021 Mediator of the Year, which is a prestigious award. The Trial Lawyers Association, they know who the good mediators are, and that's quite an award to win. She does enjoy putting on these presentations. She's happy to mentor new mediators, so feel free to reach out to her. I'm sure she'd happy to make herself accessible to anyone who has just questions in general about mediation. And of course, she is always with her co-mediator, who is a 12-year-old standard poodle named Aaron. And oftentimes he will pop up and make his presence known in the mediations. And Tom Crosby is here, another presenter. After a career as a trial attorney, Tom began mediating full-time in 2017. He typically mediates disputes involving torts, personal injury, professional liability, fraud, etc., commercial and contract disputes, trust and estates, and guardianships. As Tom likes to say, he helps parties in legal disputes control their own destiny rather than leaving it up to a judge and or jury. And I'm definitely going to ask Tom to expand on that and what he means by that, because I think that's an important thing to understand about mediation. And Tom and I we both happen to be engaged right now. And I thought it would be interesting if I could get an interesting tidbit about Tom from his fiance in exchange for him getting an interesting tidbit about me from my fiance. So he connected me with Kathleen, and Kathleen pointed out to me that Tom, while they have a lot of things in common, Tom has an over-the-top love for rom-coms and musicals. She can watch a high quality rom-com just once, and he can watch it multiple times and still cry at the end. She's seen, you know, a lot of the musicals from the 50s, 60s, and 70s, maybe or once or twice, but I was told to ask Tom, and this will be his first question for today, how many times has he seen The Music Man? So with that, I will pass the torch over to Tom to take it away.
Hello, everybody. I'm really glad you're here today. Let me just, on my pal, Lauren Tate, tell you that the last mediation I had as a litigator, Lauren Tate was the mediator, and she settled a very difficult case on behalf of my client. I was wearing a plaintiff's counsel hat that day, and my client is a renowned Bay Area textured hair hairstylist, and Lauren now goes to her. And it's so talk about win-win mediations. I haven't told that story before, and since Adam, she was not as cooperative in getting stories about her from her husband, I thought I would start with that. And it is true that I've seen the musical more than 20 times for sure. And when I was 5 years old, I fell and couldn't walk and needed a brace. And the big thing I got was to go to the musical in circa 1960. So I'm a believer in that. So, but the tit for tat is that Adam's fiance, Jessica, answered my email. And what do you know? Adam is a fan of Along Came Polly, a romantic comedy.
Oh my God.
And I was kind of curious a little bit about it. So right as we were waiting, you know how on Google things pop up, is Along Came Polly kid appropriate? And it starts with parents need to know that there are many ew moments, and it goes on from there. So maybe we could go to a movie together, Adam.
Sounds good. Sounds
Perfect.
good. I actually realized in introducing Lauren and Tom that I forgot to introduce myself. So I will be acting as moderator today and interjecting and providing my point of view. I practice plaintiff's personal injury. I'm one of the managing partners of Casper, Meadow, Schwartz & Cook, based in Walnut Creek. And I have a lot of thoughts on mediation. And, you know, most cases settle before trial, as we all know. And most cases settle with mediation, either on the day of mediation or it gets the ball rolling towards settlement. You know, mediators, depending on who they are, some do a better job of staying involved with, you know, getting case updates and major occurrences or depositions, things like that, to maybe present another opportunity to open the conversation again, things like that. And so I think knowing how to mediate a case is perhaps some of the more influential things for a good outcome for your client. And one thing for me that I think is important is keeping in mind that oftentimes for clients, mediation is really their only experience with the court, so to speak. You know, they have a lot of conversations with you. Maybe they go through a deposition, but that's just a lawyer asking them a bunch of questions. They rarely make it to a court proceeding. As I said, as we all know, there's rarely trials. And so oftentimes in terms of the client's experience with the legal world, with their case playing out in any sense, mediation is really it for the client. And I find it to be very important that I find a mediator who knows how to speak, for me, knows how to speak to personal injury plaintiffs, you know, navigate the sensitive issues of comparative fault, essentially, you know, what did they do wrong that caused their own injury? That's a sensitive topic to be bringing up, but it's an important one. And so when I use a mediator, I'm always evaluating, is this a mediator I want to use again for not only the outcome, but also how are they with my client? How do they talk to them? Do they treat them like a victim, like they think they are, whatever it might be. And I think that's important. And anyway, we're going to get into some important things about mediation, but when I'm chiming in, it's from my experience as a plaintiff's personal injury attorney. So at this point, I'll pass it along to Tom.
Well, I think I'm going to share a PowerPoint that Lauren and I are going to use. And again, welcome everybody. We're thrilled to be here. Both Lauren and I are believers in the process of mediation. And we think it's, it's a worthwhile. I'm having a little trouble moving mine forward. There we go. Adam brought this up earlier. He stole my line that it really is a party's last chance to control their own destiny. And he indicated, what do I mean by that? Well, pretty obviously, once a case gets to a judge and or a jury, all the choices that the party may have had no longer are available. And the beauty of mediation is it's voluntary. Participants own the process. And that's what I tell them, that from the very outset, that you can stop anytime you want to stop. You don't have to do anything. You don't have to settle. Lauren and I, I'm sure, both tell the parties, and Adam raised a really good point in the introduction, and it's what I love doing as a mediator, and I know from experience something that Lauren's really good at. And that's kind of leaning into conflict, leaning into the difficulties. And for many of these plaintiffs in personal injury actions, it's the very first time they get a chance to talk about how they feel. Because, believe it or not, and I'm sorry if I offend anybody here, all lawyers are not the most touchy-feely, sensitive people who like to talk about feelings and how you're feeling. And as a mediator, those questions, I think, need to be asked early on before anything can kind of really get to the point of settlement. And so that's one of the mediator's roles. And we tell parties that we're not judges, we're not arbitrators, we're not going to make rulings. But I do tell, and Lauren and I may have different ways we introduce this, and throughout today, she'll jump in, no doubt. I don't leave having been a lawyer for more than 3.5 decades outside of the mediations. And I really make it a point. Most of the time I'm talking to the parties in my introduction about what a mediation is. But at this point, I always go to the attorneys and I might say, Adam, I don't leave being a trial lawyer outside of these rooms. And there's going to be times I'm going to push back. I might ask you, do you really think that's going to get into evidence? Do you really think the judge is going to rule that way? Do you think a jury is going to buy that argument? Whatever. And the important part I want Adam to understand and hear is that there's no ego involved. There's no need on my behalf to be right. And by the way, I was a trial attorney, so I needed to be right a lot. I have an ego, but not as a mediator. And so I just say that it's my fiduciary responsibility that you consider everything with your client. And so please don't be offended if I push back or take a different position. And in almost every case, I'm not going to let Adam answer that yet. In almost every case, I get, oh, of course, yeah, no, I understand that, or I have a thick skin. Nevertheless, I think it's important to say, just so people understand, that's where I'm coming from. The mediation has a couple of forms of confidentiality that are important for everybody to understand. Most importantly is there's a privilege, and it's quoted here in front of you under Evidence Code section 1119C. And the import of that is people can say what they want to say. People don't have to be afraid. Somebody representing a personal injury client like like Adam, when I say, Adam, do you mind if I ask questions of your client? They can feel more comfortable in allowing me to do that and not have the kind of the natural instinct of some lawyers to, never let their client talk, because whatever they say cannot be used against them if this case does proceed to trial. And then there's a whole other fork of confidentiality that you need to be aware of, and that is if you ask a mediator not to tell the other side something, they won't, or at least they shouldn't. And I always have a red pen next to me and I circle something if it shouldn't be shared. But again, I may push back. I may push back and say, Adam, if you would let me share that information with the other side, I think it might help us settle this case. And Adam will, either say, I thought about that, Tom, but no, this is important to keep confidential. Or he might say, I hadn't thought about it that way. Sure, go ahead.
Yeah, Tom, actually, if I can on that point, I think that is a really interesting part of mediation. When something comes up that when I bring it up, I don't want the other side to hear, but I often do, I like to work with the mediator to figure it out. And I generally understand that the mediator, comes in our side and points out the bad things for us, and then goes on the other side, points out the bad things for us. And I sort of trust the mediator would not, would use his information as best as possible on the other side. And so, yeah, I do like sort of working with the mediator to figure out, like, should this be shared? I couch things as I don't want this to be shared, but it's always an important part of what you're sharing.
And implied in what you just said, and I don't think it's part of our outline today, maybe part of one of the articles that I wrote and maybe going out to the group. But you raised it earlier when you were talking about mediation and introducing Lauren and I, and that is, how do you choose a mediator, and what are you looking for in a mediator? You talked about what you were looking for, and implied in that was authenticity and relatability and the ability to talk to your clients and hear what they have to say. And so, that's what I got to see, Lauren. I think I do it, and I used mediators who could do it, and I've seen Lauren do it. And good mediators can do all those things. So that is what people should be looking for in choosing a mediator. And you have to have that trust that when they go into the other room, they're not going to give anything away that you don't want them to give away, and they have your best interest at heart. The other things on this deck sheet, which are last but not at all least, there is an incredible amount of savings through mediation. And what's not here, which should be here, what is here is the cost of litigation. You control the risk. We've been talking to Adam and representing plaintiffs in personal injury actions. I tell this story. I've defensed a number of personal injury cases when I was representing retail defendants, and I've come home and there's the competitive part of me. It wouldn't matter which side I was on. There's still this competitive part of me that likes to win. So I'm thrilled that I won, but I've come home and then I've made dinner for my kids and I've sat down and they've looked at me and said, you don't look as excited as you should be. And that's because as a human being, I've watched somebody go home with nothing. And I like that human being, and that human being was hurt. I'll tell that story in a more expanded way to plaintiffs in personal injury actions, just so they can consider it and feel the realness of what that might be. And when they talk to their lawyer and discuss settlement negotiations, going back and forth. So there's a savings of, cost of litigation and the controlling of risk, and the cost of litigation, obviously hits harder on the defense side, or is used with more leverage and effectiveness on the defense side often. The controlling risks seems to work for both sides. And then finally, that I don't like it as a mediator. I'll let Lauren discuss what her thoughts are on this, but some people use it very effectively to get free discovery, that maybe they go into a mediation and they never expect it to settle. And, and I'm a believer anything can settle, but they never expect it to settle, and they use it to learn more about the case, what the other side has in mind, and try out strategies, etc. So there's just a plethora of reasons why mediation is a good thing. Lauren, do you have some, I shouldn't say do you have some additions? I'm sure you do.
Just a couple of quick things, because, and I will be quick because we are going to run out of time. And when I attend seminars, I'm always annoyed that people don't cover all their material, but I know we're going to run out of time. And sometimes that's okay. If it's with your questions, then that's great. But the free discovery thing, I'm very mindful that that's not the purpose of mediation. And I don't let, if the parties seem willing to exchange information, that's great. I don't get in the way. But you have to be mindful, and a good mediator will protect you from giving out information that, wait a minute, they didn't take my client's deposition. No, they don't get to talk to her, et cetera. So one thing I want to say is the mediator is your client. You have retained a mediator, and you need to make it clear to the mediator what you need help with, what you want the mediator to do, and what you don't want to do. So for example, a lot of times people tell me, I don't want this to turn into free discovery. So we need to be mindful of that. If you back up just a second, I just want to highlight, because I think this is really important. In terms of the power to control the outcome, the plaintiff knows, let's say a personal injury case, the plaintiff, and I tell them, you know what's true. You know how this accident or incident felt at the time. You know how you felt in the days, weeks, months, how you felt riding in the ambulance. You know how you felt in the days, weeks, and months following this, how you're still impacted by this. You know what's the truth. But if you go to trial, and right now you have 100% control and power to make the decision about settling this case. And I tell them, but if you go to trial, you take that power, and I literally do this in every case, and you hand it over to 12 people who don't know you, who don't know your truth. And what matters, of course, to you is what your truth is, but what determines the outcome is trial is what the jury decides to be true, what you can prove to be true. And you have to consider what giving up that power means for you. Okay. And so I think that's a really powerful message to tell plaintiffs. You can also acknowledge their truth and not get them to give up their truth in order to see why it might make sense for their case to settle. In other words, the jury may not view certain pieces of evidence the same way, or there may be certain pieces of evidence that are consistent with that truth. But just talking to the plaintiff about the reality of giving up the decision to a jury and how that can affect the outcome, I think is really, really important. Also, one very important thing about mediation is it allows the mediator to break the bad news to your client. In other words, this neutral party who's acknowledging the strengths of a plaintiff's case can also, once you make a connection and earn some trust, you can also deliver bad news that's very hard to hear in a way that's very humane, acknowledging that it's hard to hear, but they need to hear it. All right. And you're talking to the other side about the strengths and weaknesses of their case in delivering news, but defense attorneys and claims people, they can take it. But it's really allow the mediator to do that for you, because people need to be in a certain mindset before they hear that bad news. So I just also want to add, mediate as early as possible. As soon as you have the information and the other side has the information you need, do it, because before you spend all the money and get too invested, that's the time you can get your case resolved. All right, when does mediation start? So I think this is me. I'm going to be fairly brief on this point. I don't know if you're all new lawyers, these are basic trial skills, but I want to really emphasize you start mediating when you first get a case. When you first speak to your own client, you're mediating in some sense. The moment you look at that case, you should be thinking, what is my strategy going to be in this case? You pick up the phone and you talk to the attorney on the other side. You are starting a relationship and you are mediating in a way. You look at a case, it's a case of liability as a defense attorney. You call up, this looks like a case we may want to settle. I'm not sure yet, but we may want to settle it. So why don't you get me X, Y, and Z? I'll take your client's deposition and get the records, then let's mediate. Okay. So in other words, you pick up the phone, you're speaking to them, you're developing a strategy together, you're mediating. And remember, you can control to a large extent the relationships that you form, and you find yourself mediating your case all the way through with this mindset. There are times when you are not getting along with other counsel. Think about taking a breath and stepping back and calling them and saying, I don't know how we got off on the wrong foot, but I'll own whatever, I own about that. Can we try to change things a bit going forward? What do you need from me? And there are some people who are jerks. That's never going to happen. You can't stop the the negativity, but you've tried. So think of yourselves as mediators, even while you're handling a case. I see that some of you do trust in estate litigation. Boy, you are mediators, whether you know it or not, if you're successful in that. Family law, again, if you think about the concept of mediating and what it means, I think you'll all start to realize you are already mediating in your own practice. And you don't stop, even though you're not acting as the mediator in a mediation, you don't stop that. But the idea of this, even if you're not going to do mediation as a living, really be thinking about these things we're talking about and using them in your own practice. And I will say extends to family relationships as well. But in fact, I really think you should all do some mediation training, even if you never imagine you're going to be mediators. I think it really makes you better lawyers. So,
Lauren, let me throw in one thing. If you're a newer lawyer and you are not yet going to be the person that gets to go to the mediation or control the mediation, you still play in a really important part, or can play a really important part. If you're getting answers to interrogatories, if you're doing summaries of discovery, and that's the time to share the difficult parts with the partner who's going to be in charge of the mediation, et cetera. You can really have an effect on things, and those partners, whether they know it or not, need to know about your client's feelings or failings or what have you. So keep that in mind as you begin your practice. Lauren, you're still up, and
all right.
And I'm trying to do something here and it's not moving. There you go.
Okay, pre-mediation conference. Now, you hire a mediator that you trust. And again, a lot of people are kind of intimidated and think that mediators are kind of like judges. You're not supposed to talk to them ex parte. No. You want to talk to them ex parte. You want to tell a mediator who you trust, what you want to accomplish in the mediation, what you're afraid of, how you need help with your client, how you need help with the other side. You want to get this case settled because there is some evidence out there that they don't know yet that's not helpful. I need to get this case settled, et cetera. So absolutely have a pre-mediation conference. And if your mediator doesn't reach out to you, then reach out to her and say, hey, can we talk before the mediation? You want to have a very clear intent in your own mind as the attorney representing a party. What do you want to accomplish? A lot of times it's just money, but again, in family law, in trust and estate litigation, relationships, either somehow rebuilding or taking what's become a disastrous relationship because of the conflict, somehow helping heal that, getting the parties to a place where they can move forward and have some kind of relationship. Maybe it is just the money. But in any event, really think about your intent. And Tom and I both submitted articles that I think you're going to get. The format we were asked to write was top 10 tips on, preparing for successful mediation. And I literally tell people, stand there, close your eyes, and really write out your intent. Think through, what do I want to accomplish, and make sure everything you do and say is consistent with achieving that goal. talk about with the mediator, in a forthright way, things are going to be barriers for the other side. Tell them what you need. I need you to break the bad news to my client. They think this is a 7-figure case. There's no way a jury gives them more than, 100 grand, whatever it is. Talk about the logistics. Do you want a joint session, which we're going to talk about? Your client is very uncomfortable being on Zoom or this or that, or gee, my client has their kid there, whatever. And really tell the mediator what you need and ask the mediator, so how you're going to structure this, and make sure it's consistent with what you and your client need. But really do use the pre-mediation conference. I think that a good pre-mediation conference not only saves a lot of time in the mediation, but I can almost predict, after talking to both counsel, whether or not the case is going to settle. And it's not always just about the amount of money, but I can just really get a good sense of where we're going. So I would not mediate without doing this. And I wouldn't recommend as a party you do it either. I still, by the way, represent clients and participate in mediation. So since I've been mediating, I've really honed my pre-mediation conference skills. So I encourage you to do it.
One thing I wanted to bring up that does sort of start at the pre-mediation conference is you have to kind of develop your own personal style with all of this, as with anything in the law. And that style can change depending on the case, your clients, your relationship previously with the mediators. And when I first started out in civil law, I went to mediations with all of the more senior attorneys, and they all had such differing approaches in terms of their relationship with the mediator. One attorney in our office, it was like the mediator was opposing counsel, argued on every point. No, he refused to accept anything the mediator had to say, went toe to toe on every issue. And that was just his style. That was just his approach. He felt like that was the best way to show his hand and advocate for his client. It's not my style. Another more senior attorney in my office, he showed up, and like from the get-go with the mediator, they sat down and they said, all right, what's the game plan for this case? And it was like they were on the same team, and it was such a distinct style from the other attorney. And I was sort of realizing that I got to develop my own style. My own style falls somewhere in between the two of those. At times I, kind of depending on the case and the facts and my client, sometimes I'll advocate maybe a little bit stronger in front of my client. And if the mediator knows me, they kind of know maybe what I'm doing. It's the first time, maybe you have to kind of show your client that you are going to fight for you if you think that's important to start to win over their trust. There's all these kinds of things, but this really gets to, I think it's important to be really premeditated about your approach with the relationship with the mediator, because they're the ones who have a line with the other side. Generally, if you're nice to people, they want to work for you. If they think that you're nice, it's just a part of human nature that they want to do well for people they think are good people. That's what I think. And that starts with the pre-mediation conference, just showing up, kind of setting the tone with the mediator and things like that. It starts with the pre-mediation conference. The pre-mediation conference is very important to, get even though you've said it 3 times in the brief, I still like to repeat it, 3 times in the first conversation of what your strong points are. You can never say it enough. Even when the mediator says, I got it, then you still say it again, whatever it is. But yeah, the pre-mediation conference is important, but I encourage you to really think about how you want to approach the relationship with the mediator.
Yeah, Adam,
go ahead.
Go ahead. I was just going to say in the chat, Ariana asked, can you really briefly touch on the duty of confidentiality to your client and the pre-mediation conference with the mediator? I'm not exactly sure what that means, but it feels like it might mean, are you breaching any confidentiality by talking to the mediator about your client's case? And I would think not, because it's under the confidentiality mediation privilege, but Lauren and Adam, do you have thoughts?
Well, I
Yeah,
will say this, that you really have to trust your mediator. If you want to divulge something to the mediator that you do not want communicated to the other side, you need to have some level of trust that you know that mediator won't communicate it. There are different layers of communication that you might, you know, if you haven't worked with this mediator before and you want to be careful, you may want to just, you know, be mindful of that. But technically, Tom's right. It's all within the mediation conference or the mediation privilege. And the mediator is duty bound to keep confidential from the other side things that you request. So, you know, if the goal is to get the case resolved in a way that you think best serves the interest of the client, I don't think there's any, I think you should want to communicate the information the mediator is going to need to help you get that done. And you shouldn't be concerned about client confidentiality because that is contained within the mediation privilege. But again, you need to use a little common sense. The
yeah.
other thing, oh, go ahead, Adam.
No, you can continue, then I'll follow up.
No, go ahead on that point.
No, this is a really great question because it's one, again, think about this ahead of time. You have to really balance, you know, client confidences are a big deal. Things stated to the mediator are legally confidential. And so often the way that I dance around this issue, feeling confident that things I say to the mediator will be confidential, is just the way that I phrase things, rather than, you know, saying like, well, my client said this or my client said that, you know, things like that. Getting across, if your client tells you something that is good for the case, you can figure out a way to communicate it without it clearly being attributed to the client. Because if it's a good thing for your case, you got to be getting it out there. It advances your client's cause. And I think even though things are legally privileged with the communication rules, the confidential rules, you still want to be careful about that. And like Lauren said, you trust in the mediator. At times you can be explicit with the mediators about what is not to be shared, and they should, you know, follow that. I think it would really, they risk, you know, sort of their own reputation. And I think mediators get that. If you told the mediator something and it came out and you said you didn't want to, that they understand that could burn their career. So they do take it seriously, all of them. They're aware of that distinction of, you know, what's to be kept to one side and not shared. So I think it's a really good question because there's a lot your client tells you that is confidential and attorney-client privilege, and they are the ones who hold the privilege. But I do think that there are ways, if you do think about it, to phrase it where you can communicate it without violating any duty owed to your client.
And just as a practical matter, to assuage your fears, I know Lauren and I want to continue to do this as a profession. We love doing it. And the first way to never get a case again is to breach somebody's trust and confidence. So we're very careful as mediators. And I would hope others in our profession are too. I've heard some horror stories, but which is why Adam is right. You can be careful if you're concerned. Lauren, you wanted to go into something else, I think.
No, time-wise, I think we should.
Okay, let me jump
There you go.
into mediation briefs. And I will also try to be brief. Funny. Just like any other legal writing, who's your audience? Your audience in this case is both the mediator who's trying to help you settle your case and will do everything they can to do that. They're going to be neutral. They're going to help settle the case for both sides, and you get into a compromise settlement. But the other party is the opponent, or the other audience is the other side or sides. And, we've all been to law school. We've all seen the different people that can go to law school, and we've all experienced lawyers. Adam has this nice, calm approach. I imagine he can not be calm if he needs to not be calm. I haven't seen that, but we write here, educate, don't intimidate. Honestly, I don't think anything comes of the bullying, embarrassing, a lot of time spent on undercutting a plaintiff. It's really not necessary. And it seems to work against lawyers who try to do that. Like any writing, be brief and be direct, and don't include unnecessary materials. And so what do I mean by unnecessary materials? As a mediator in a personal injury case, I don't need all the medical records. I don't need a PDF that is 161 pages long in medical records. If there's a independent medical exam report, of course, I want to see what the defense is trying to put forward in that regard. If there are reports from the plaintiff's side, I want to see that. But the brief if you're representing a retailer in a slip and fall case, I don't need 4 pages of the Hornbook law on notice or constructive notice. I need to know how what the facts in this case are and how they play out in that area. I need to know the important things and not the unimportant things. And so does your opposing counsel need to have that. And the person, if you're representing the plaintiff, the person that's paying the money wants to see that stuff. So I would, again, I would include the important stuff. I would avoid the kind of derogatory comments and the letting one's ego get involved on the brief. But Lauren, do you have some thoughts on that?
I do. So I always tell people, don't ever confuse being aggressive with being effective. And what you want to do, I read so many briefs that are so aggressive and off-putting, and my first reaction is, wow, I wonder if they really feel this way. I feel like if you really feel strongly and confident about your position, then you can set it forth in a really calm, straightforward way, where you could look someone straight in the eye and say, this is your position, this is what it's based on, and this is why you feel it's what the jury will decide at trial. You don't have to say that someone's lying. The plaintiff's deposition testimony was inconsistent with the medical records. And then you go in and you point out why. Plaintiff's version of how this accident occurred is inconsistent with the witness statement, et cetera. There are ways to communicate your position without offending the other side. I always tell people, write a brief that you would not be afraid for the plaintiff, him or herself, or the defendant individual to read. In other words, you would want them to think, oh, I didn't realize that was, I do like some law, no strict liability. I think if a plaintiff reads, a lot of plaintiffs feel like they fall somewhere, the store's responsible, not the law. So brief recitation of the law, I like, but let the plaintiff read, oh, that's kind of a good point. Oh, gee, I see what I'm going to be up against if this case goes to trial. A lot of attorneys don't have their clients read a brief. I would. So I would hope the defense attorney would write a brief that would be effective and not send my client into an emotional tailspin, but really, as Tom says, educate, not intimidate. Because after all, we're here to communicate to one another what our positions are, what evidence we think support them, and go back and forth with those positions to get to, hopefully a point where the case can resolve. So really consider the tone. And it's like with every other communication with opposing counsel, don't be a jerk. There's no reason to. If you feel comfortable about your position, you should be able to talk about it in a way that's, you know, very straightforward and professional. So really be careful with the tone. I like people to highlight important parts of the medical record and then attach excerpts about those important parts so that I can use them. For example, if a plaintiff says, oh, never complained of neck pain, and the records show that there were several complaints, you can actually screen share and say, the defense will use this to show blah, blah, blah. And probably you didn't remember that, but gee, you said you didn't have that before. So that might affect how a jury views this, et cetera. So I like that. Just excerpts of deposition testimony, if you really think they're important, cited in the brief, attach those pages. Summarize your expert opinion from the IME and then attach the report. If it's 1,000 pages, you don't need to do that. Maybe you attach the conclusion part. So just really be mindful. I always tell parties, share briefs. It saves time. And if you don't share a brief, no one from Southern California ever shares a brief. They act like they're protecting, nuclear or super, classified government secrets. There's never anything in them that's confidential. They just don't share briefs. I say, okay, well then let's schedule in two extra hours because we're going to need them. Share a brief. And then if you want to communicate to the mediator, I have one person I mediate for all the time. He represents airlines. He always does a brief that he sends to the other side, and then a 1 or 2 page confidential document brief to me for my eyes only. And that's the way to do that. Communicate information you only want me to. And a lot of times it'll say this plaintiff is a horrible witness, but he doesn't want to put that in the brief because that's not productive. So keep in mind, educate, don't intimidate. That's Tom's statement, and I think it's the best, the best advice.
Yeah, let me just briefly add my advice on this point, which is not too dissimilar to what Lauren and Tom have been saying. And I think that this applies to all areas of law in terms of just writing a persuasive document that's going to be read by someone who is against you. I remove hyperbolic language. If all you need to prove is that the defendant was negligent, don't say the defendant was extremely negligent. Like it doesn't add anything. And then if you have, 10 paragraphs in a row with that hyperbolic language, chances are there's been this gut reaction by the other side. Every time they read it, they're like, I don't think that's true. I don't think that's true. And so then when you actually get to the issue in dispute, whatever it is, causation, I don't know, in trust and estate litigation, I don't really know what that might be. But if you get to the heart of the matter, they're already kind of against you, they're disagreeing with you, and then you make your point, you have no credibility, and you've lost. But if you've got 10 paragraphs in a row where they really can't disagree with you or they don't have a bad reaction, when you get to that really important point, you have credibility when you say it. That's my advice. It's what Lauren and Tom have been saying, but.
Let me go on to preparing for mediation, both yourself and your client. And first of all, that's been discussed. Adam's talked about it. Lauren's talked about it in various forms. So one thing you might do when you have a mediation coming up is look at this deck and just quickly go over the 10 or so slides and just make sure that you've done some of that. But a lot of it needs to be done in advance as well, as Lauren talked about earlier. But in sitting down with your client, especially in Adam's case with a personal injury client, you want to just talk about what you should wear, and if it's Zoom, in the Zoom world, how you get on Zoom and what that's going to look like, and kind of what the parameters of that are. And you'll have some time alone where you can go off and, like Lauren could go feed her dog and all that kind of stuff. There'll be those separations, and talk about the importance of authenticity and help your client feel comfortable. Because honestly, if somebody can't handle the likes of Lauren or I and how welcoming we can be and how easy we make the process, they're going to have a really hard time sitting day after day after day in a trial. And you can talk to them about that as well. But and just prepare them for difficult questions, and And that's on either side of the deal. You know, if you've got I use an example here, if you have a personal injury client and they've had 2 prior surgeries, how do you be ready to explain why this third insult to their body is the one that really stops them from working, stops them from enjoying their kids, stops them from doing the things they want to do, you know, because that plaintiff has a right to compensation for the exacerbation of any pre-existing injuries, but they need to be able to explain in a cogent, believable fashion to the side that's paying the money why it really happened in this case, and be able to distinguish those things. And then, you know, I use another example on the defense side. If you have a floor walker in a retail establishment, and I represented one of the biggest for 28 years, it was never a good thing when you got a floor walk and the person did it in 10 minutes. And even in my younger days, I couldn't walk the whole thing in 25 minutes. And so those are the kinds of things that make it difficult to explain, and you got to be ready for those things. So preparing for the mediation and looking and doing all the things we've already touched upon is extremely important. I'm going to skip to you now, Lauren, to talk about joint sessions.
So I just wanted to make a brief point about preparing your client. And I think this probably applies to most areas of law as well. But what happens a lot in my cases is the first offer really offends my client. And I tell my client, I warn them over and over, the first offers doesn't mean anything. Please don't be offended. I can't tell you how to feel, but you're probably not going to like it. And I let them know where they start is not an indication of where they're going to end up. And you want them to hang in there. Mediation takes time, takes hours on that day, it may take weeks, and you don't want your client just turning it off immediately. So I warn my clients, and this probably applies to all cases where you show up. Sides are either just posturing, they're making a business decision on negotiation wise where they want to start. You know, I warn my clients where it starts is not where it's going to end up. But going on.
Yeah,
That's a good point.
It's a really good point, and it reminds me of a couple things. One, Lauren's going to talk about negotiations in a bit, so that fits into your mindset on what's going on with negotiations. But it also, I make a big point in my mediations of looking now on Zoom for the last year and a half or whatever it's been, before we ever get to negotiations, and after I've explained what mediation is and all the kind of the ground rules, et cetera, you know, I'll say to them, and after I've spent time with the plaintiff hearing about their injuries and the effect on them, et cetera, and then I'll just say, you know, the only way we can compensate injuries in our country and our system is by payment of money. And at some point, we're going to start talking about money, and we're going to be going back and forth. I just want you to know that I have heard how you've been hurt, and I empathize with you. And I've had enough orthopedic injuries that usually I can say, you know, let them know that I empathize and I know exactly what that surgery was like, et cetera, et cetera. But I just tell them, I'm not going to forget when we start talking about money what happened to you, and you shouldn't think that any of us are forgetting what happened to you. And, you know, it's also easy to explain to them that there's human beings on the other side and they care what happened to you too, but they're just doing their job and trying to, you know, represent their clients or lower the effect on shareholders, whatever the case may be. But it's important, I think, of you as lawyers to let them know that as well, that there's going to be that transition and nobody's going to forget what happened to you. Anyway.
So I want to just add, and that slide and this slide kind of go together, is I don't think attorneys are all that good at preparing clients. And I don't do family law mediation only because I think there are too many areas that, you know, tax implications, et cetera, that I think you really have to know kind of the basics of family law to be effective. And I'd like to do it because I think I would be good. But I tell people, estate, and probate litigation, my God, these are gut-wrenching things. Children having time with their parents, homes being taken away, money being split, betrayals, etc. Parents who, will contests, parents who leave money to one and not the other, and was there influence, etc. I mean, these are gut-wrenching, core emotional issues. And then personal injury, you're dealing with someone who may be severely in life-changing injuries, and these are difficult things. I tell participants in a mediation, litigation is hard. This is hard. And in this mediation, you may, become really angry. You may cry. You may be frustrated. You may be offended. And all of those things are fine. I don't mean I want you to feel them, but I want to hear from you about that. You're going to hear things that are hard for you to hear. You're going to have to respond to positions that the other side has. You're going to have to listen to them. I don't expect you to agree, but you're going to have to listen to them. And then I need you to you can get angry, you can, however you want to react, but then at some point we all have to decide how you're going to respond. All right. And I can help with that, but you're going to talk to Adam or whoever the attorney is. But I prepare them for what's going to be difficult. I tell them this is your mediation and I want to hear from you. I tell them you need to use your lawyer and push back on your lawyer. You push back on me. You ask questions. I want you engaged and involved. But this is hard. And there's nothing you can do or say when we're in our private session here with your attorney and me, the three of us or whatever it is, there's nothing you can do or say that would be wrong. Okay. So I really prepare them that we are going to get into this and we are going to talk about these issues, and this is hard. And when I think about some of the issues that, again, in family law and, trust and estate litigation, I mean, those are the two areas that I know someone is in that's here. These are, it's difficult. I tell plaintiffs, you will be offended and angry by the first offer you hear from the defendant. That's just how it works. The defense thinks your demand is completely unrealistic, all right? And they may come in with something so low that and that's okay. You react however you're going to react, but hang in there with me. I'm asking you to be patient because it doesn't matter where they start, all right? We know they're going to pay more. We know you're going to accept less. Let's just hang in there. And it may seem childish and it may make you mad. Go with me here because the play's the thing, all right? We're gonna make this work, all right? So I prepare them because I don't expect their attorneys will have. Attorneys are so caught up in the law and what do I have to prove and this and that. They forget that people are terrified by legal processes. Depositions are intimidating. Trial would be terrifying. They don't know what to expect from a mediation. Most people tell me, oh my God, I didn't know what to expect. And this wasn't unpleasant at all. I mean, I know we didn't settle, or if they did settle, they're elated, but I really did feel, now I get it. Now I get what I have to think about. And it's just interesting to me, but we can't forget that most people don't know what they're coming into. And you really need to sit back and say, okay, how is my client likely feeling about this? How are they viewing this process? Really think about it and do help prepare them. I'll prepare them anyway. I know Tom does too. A good mediator will, but anyone that just gets in there says, okay, here's their position. What's your response? That case isn't going to settle. So joint sessions, Tom and I have different views on this. Pre-Zoom and post-Zoom. Right now we're in the Zoom world. So I always like to do at least a meet and greet. I think for one thing, as corny as it sounds, it signals a coming together and a willingness to come together physically, even if it's on Zoom, which is somewhat safer. Now, family law can't always do it. Sexual assault or, employment cases, sometimes you're absolutely not going to do it. There are good reasons not to do it. Estate disputes, may not be a situation where you can do it. But unless there's some barrier like that, I want the defense attorney and the claims person to lay eyes on the plaintiff and say, this is a real person. You may not agree with the extent of injury. You may not agree that it was your fault, but it's a person who was injured. I want you to put a face with their name. All right. I want the plaintiff to see, here's the defense attorney. Hi, I met you at your deposition. Good to see you. Hopefully you weren't a jerk, so you haven't offended them. Another reason to be effective, not aggressive. All right. Oh yeah, it's nice to see you again. I think, well done, defense attorney. Okay. The claims person, hi, plaintiff, this is the claims person. He works for AAA. All right. He has a job to do. He needs to document his file. He has someone auditing his files and breathing down his neck. I want people to understand these are human beings and we're going to try to get this resolved. So just a meet and greet, even if I'm the only one that speaks. I love Zoom because there's always something in someone's background. Like maybe plaintiff will have a piece of kids' artwork. So I can say, oh, who's the budding artist? And they'll say, oh, that's my 5-year-old, blah, blah, blah. Okay. Or here comes a pet. Here comes a cattail across the stream. And I'll say, all right, who's that? Oh, it's Mr. Whiskers, and suddenly people can connect without talking about the case. And it really humanizes everyone. I make fun of myself in terms of technology because we're all struggling, etc. There are real opportunities to talk about someone's background or, say something that's, maybe kind of lightens the mood or just really connects or, oh, it took me a long time to get on Zoom too. Oh, great, we're all here. So I really like a joint session. I think it's helpful, even if it lasts 30 seconds and everyone just says, hi, nice to meet you. Boom, we're back in our own rooms. There are times where plaintiff's attorney will tell me my client feels like they need to say something to the other side. I have certain defense attorneys who always like to talk to the plaintiff and say something like, in a personal injury case, we are so sorry that this happened on our plane, or we're so sorry this happened in our store. We're here to try to get this resolved. Okay. It's not a fake apology. It's an acknowledgement that something happened. They're sorry that it happened. Let's try to get this resolved. There are real opportunities that I think people miss. Again, in the article I wrote, I don't know if Tom's addresses this, but I talk about all kinds of reasons to have a joint session. I feel strongly about them. I recently took a mediation training that was promoting every mediation always be joint all the time. You never go to private rooms. I think that's insane, but interesting idea. But the more you can come together, makes sense. Also, don't if a plaintiff's attorney says to me, yeah, we'll do a joint session, but then his client comes on and they look terrible. They're wearing a baseball cap backwards. They're in their car, or their background is just such that it's just not painting them in a good light. They're not dressed appropriately. I'll say, you know what? I'm not really comfortable. I think maybe we shouldn't do it because I don't want your client to be at a disadvantage because of what's going on in their life and what they had to do to get here today. So really you have to be fluid about it on Zoom especially, but don't turn away from the opportunity. Obviously, if your client's going to speak, regardless of what side you're on, you need to know exactly what your client's going to say in terms of kind of the scope. Let them use their own words. Don't prepare them to the point they don't sound like themselves, but really be clear on what questions are going to be asked and by whom, and what your client's going to say and what you don't want asked about. So be very clear about that. Again, that's the pre-mediation conference that you need to work on.
So I'll push back that we have different opinions. Perhaps on Zoom we do. Pre-Zoom, when we're at a conference facility, I always want to have a joint session, but I am really careful about it. I'll meet with the plaintiff's room and I'll go through my spiel about what a mediation is, what my role is, how they control things, how it's voluntary, yada, yada, yada. And I tell them that we're going to meet all together and I'm going to say exactly the same thing. And I'm going to say, I'll have asked them, have you ever been to a mediation before? No. Do you know what it's about? No. And you know what? You touched upon it earlier, Lauren. People are intimidated. People, you know, they're around all these lawyers in suits or whatever. And I don't know about you folks, but when I'm in that mindset, I may not hear something the first time through. So I tell them exactly that. You know, you may not hear me the first time, so I'm going to say exactly the same thing. And I believe with you all in the same room, there's sort of a psychic effect that will help us in the end towards cooperation and a compromise today. And so bear with me. And I'll, in each room, you know, I'll ask the plaintiff's lawyer whether the plaintiff wants to speak and talk about what that would involve and what the, you know, how it would go. And in the defense room, I'll ask the defense side, you know, do they want to say anything? Does the defense lawyer want to say anything? And if he or she does, I'll want to know kind of, what do you plan on saying? And I will really steer against anything that's argumentative. I, as a lawyer, would always take advantage of that opportunity to be very authentic. And it was true, you know, I'm sorry you got hurt. But if we take different positions here today, it's because, you know, we're representing our client and following the law, et cetera, you know, but it's a really good opportunity for you as lawyers to use the system if you can have a joint session. I frankly have not found it to be effective or helpful in the Zoom world. I've had situations where the plaintiff actually ended up not being able to attend. And I've told the plaintiff's counsel, look, I'm not going to tell the other side the plaintiff's not here. I'm not going to lie either if I'm asked, but you know, things happen, and we you know, I'm working with you here. Nobody needs to know. But also sometimes people just don't feel comfortable on camera in front of the other side. So for me, counsel have been really against joint sessions in the Zoom world, and I've respected that. Pre-Zoom, I might not respect it. There's this whole, you know, we made fun of Southern California earlier. Southern California doesn't want any joint sessions, and that may be creeping up to the Bay Area. But I usually am effective in convincing lawyers to participate with me on a really controlled joint session to start when we're in person. Thanks, Lauren.
One quick point. I know we're trying to get through the presentation, but I always find out if a mediator intends to do it. And if they do, I ask my client if they're comfortable saying something. And if they're not, I just let the mediator know and we go from there.
Yeah, it's interesting too. If a plaintiff says, I don't want to see, or the defense, or whatever, the husband and the wife, I don't want to see so-and-so. Oh no, I don't want to see that guy. And I often will say, I don't blame you, and that's okay. Let's not do that today. That's fine. But I need you to think about, one of the things about going forward is, how will you feel having to go to the same courthouse, the same elevator, the same hallway, the same courtroom for 8 to 10 trial days, and sit within 20 feet of this person and listen to him or her say things that you know are not true. So that's one of the things you need to think about in deciding whether you want to get this case resolved or whether you're willing to go forward. So even talking about the joint session can really be an effective thing to talk about. The other thing I will say is, oftentimes in talking to one side or the other, I will say, you know what, are you willing to say that same thing to the other side? Because the way you just put that was extremely compelling. And if you are, I think it would help us get past this issue. And then I have the plaintiff, or the party and the attorney, talk privately about whether they want to do that. Then I talk to the other side about whether they want to hear it. And then we either do it or we don't. But just because you haven't done a joint session at the beginning doesn't preclude people from coming together. For example, family law, you have to deal with custody, this. If there are 3 issues that people essentially agree on, but you have to hammer out some details, maybe that's a point you can come together and just hammer out those with an agreement that both sides won't raise the third rail issues that would cause that to just blow up and be counterproductive. So be fluid and don't feel like you're at the mercy of the mediator. Tell the mediator, hey, I would like X to happen. Can you make that happen? Or is it possible to have this? make that happen. All right. So, you know, again, use your mediator. We're your client. What do you need from us? And I mean, in a neutral, you know, how can we help you get this case resolved? So,
Speaking of that, Lauren, keep going and talk about negotiations.
okay, the expectations are the one thing that just, it makes me insane. Now, I will sometimes have an attorney tell me, Lauren, I know I have a problem with liability or causation or whatever, but I have to, at the mediation, I have to be a super strong advocate because my client really needs to hear that from me. But please know, I agree with, you know, the fact that there are some issues and I need you to help me with that. So I know ahead of time, we're going to be kind of like good cop, bad cop, fine. But lawyers that don't prepare their client in terms of expectations, you know, lawyers that make the demand of $2.5 million, knowing full well that this case has a settlement value between $150,000 and $200,000, you know, it just makes me crazy. Sometimes the lawyer doesn't have the ability to make a less than 7-figure demand because the client's demanding it. Okay, well, dealing with unrealistic expectations is difficult and it's time consuming. So really try to have good expectations with your client. In a family law situation, if the judge is the default, the judge is going to, you know, grant X custody to each parent or X child support or whatever. Make sure your clients know that. So if they want to get a better deal, they're likely going to need to make some concessions somewhere else. I mean, in terms of recovery of a personal injury case or, you know, whatever it is, prepare your client's expectations. If you can't, tell the mediator, my client's expectations are out of this world. I need your help. All right. So what happens when you go into a mediation? Again, we're using the default sort of personal injury. The plaintiff's demand is $2.5 million. You know, this case has a value of, you know, low 6 figures. All right. You can do one of two things. You can say, as the defense attorney, you can say, okay, I'm going to ignore that. And I'm going to negotiate to the value of my case. This is a liability case. The plaintiff was injured. The plaintiff has $15,000 of medical bills. I'm going to make an opening offer of the entire medical bill of $15,000. And I'm okay, fine. Or they can say, oh, $2 million, fine, we'll waive costs. All right, that's sort of the petty, snarky response. And I understand it. What I've come to realize is it really doesn't matter how you respond in terms of the number. It's the message that the mediator takes with the number. So if you can't help yourself and you're going to just do the petty response of, you know, waiver of costs or $1,500 in a case you know full well has a 6-figure value, and in fact, you brought 6 figures with you. If you just can't help yourself, then tell the mediator, I can't help myself. The demand is so high. I'm afraid that if I engage in this, you know, I'm just going to encourage him to stay high. Fine. Then what the mediator does is say, look, they're offering $2,500, and it's really as simple as this. It's a response to the demand being so high that they really want you to know they do have money. They came here to settle the case, but this case doesn't have a value of $2.5 million, and they want you to make a move that shows you really are interested in settling this case, et cetera. Okay, fine. I like the other approach better, which is the 15,000 or whatever, 25,000 or whatever it is, to say, look, they were tempted to do this really low, offensive, you know, offer in response to the $2.5 million, but they're not going to do that. They're acknowledging that this was their fault. You have this much in it. So they want to start with the medical bills. They have more money, but that's where they're going to start. So it's to try to take the emotion for your client and the emotion for you as the attorney out of the equation. Step back and say, does the demand that a plaintiff makes at the beginning of a mediation, does that affect how I'm valuing the case? It may affect my opinion about whether the case can settle, but it has nothing to do with what I think is the value of the case. All right, I've taken the deposition, I've reviewed the records. I think I've realistically evaluated what a jury is likely to do, within a range. So no, it has no bearing on that. So why react to it? Why give that number power? I would say ignore it. Okay, they can't help themselves, whatever, needed to do it. The client needed to see them being really, okay, fine. Again, anytime you're negotiating, and we'll get into this a little bit more later, but anytime you give the mediator a number, you want to give the mediator a reason you're giving that number. And you want to make it very clear what message you want the mediator to take. So I will often say to, let's say the plaintiff makes a demand of, whatever, $100,000. The defense says, okay, we're going to start with 15. Okay. I tell them, that signals to me something kind of in this range. And so I just kind of want to throw that out. And they might say, oh, no, well, we don't want to signal that. Let's do this. Okay, whatever you're comfortable with, go back, etc. But I tell them, tell me why you want me to take that number and what the position is and what you want me to say. Again, the mediator should be doing your bidding. Now, if someone tells me, I want you to communicate to the plaintiff X, I may say, all right, if I do that at this point, I think it might backfire for these reasons. All right. So it's a process. It's a negotiation now between the lawyer and the mediator in terms of what's going to be most effective. But really, it should be a discussion. So, Tom, I think you might have a little bit of a difference of opinion in terms of the stratospheric demand and the initial insulting offer.
I don't know that I do, but when you hire a mediator, you're hiring them for their judgment, and it's really a fluid kind of judgment thing. And Adam touched upon this a little while ago, and the importance of preparing his clients for not reacting to the first offer. And that's true with all of this. And the idea of pushing back when somebody, they say, what do you think of that offer? And I'll say, well, I don't like it, but, I can deliver it with the message you want to deliver. That's no problem. Because we really do become, in fact, sometimes we have to fight against being on one side or the other. But we really are, we are fighting as mediators on behalf of both sides for a resolution, because we believe, in our heart of hearts, for all these things listed here, there will be attorney's fees and costs. There'll be those psychic costs. There'll be loss of control, all these other things that if we could get this case settled, we're doing the right thing for everybody involved. And so a lot of it, I agree with Lauren, it's in the messaging, and we're going to run out of time.
On that point, let me just, we have 5 minutes left. And what I propose we do at this point, I would like to, depending on Lauren and Tom's schedule, we didn't talk about this. We may go after 6 o'clock. People, if they want to be done, they've done their hour and a half, they'll credit. We can continue going for a little bit. We won't, I have to eat dinner at some point. I am a hungry fella. But what I would like to do at this point is just check in. We do basically what we have left is continuing to talk about negotiations and then talk about the settlement agreements, what that means, how to get the best agreement written and confirmed and all that. We're going to get into that. But at this point, if anyone wants to chime up with any more questions, otherwise we'll just keep going. There's a few of you here, so give you, a couple seconds to chime in. And if nothing, then we'll just continue.
Are they able to chime in as it's set up as a webinar?
On the chat, there's all right, not seeing any more questions, then
Tom, can you go to the next slide?
I don't know.
I don't know.
There you go.
All right. So the goal in negotiation is obviously to try to taper. You start, here, and, you're going back and forth with positions and numbers, and you're trying to taper and make the V shorter. You're obviously not always going to meet right in the middle, but you're trying to get to what I tell parties is the sweet spot. It's not your worst day at trial. You wouldn't accept that. It's not your best. That's not realistic. There is a range in which the jury's going to decide. All right. There may be a low and a high of that, but in terms of what a jury's going to do, a reasonably likely outcome. And I tell people, you're going to hear a number today and your attorney's going to say, don't pay that or don't accept it. I think you'll do better at trial. But the goal of a mediation is to get you into the range where your attorney has to sit back and say, you know what? I can't say that I feel confident that you're going to do better, likely going to do better. You could, but you might not. And then you're in that sweet spot and you really start thinking long and hard about settling, but that's what you're aiming for. So keep in mind, what is your goal here? What is your goal? And work toward that. And if your goal is to get this case settled in the $200,000-300,000 range, staying up at $700,000, isn't going to be effective. So really, and listen to your mediator. If what you want to do is signal X, then I suggest you move here. Or plaintiff's attorney says, okay, we're going to move to here. Okay, that signals to me you're going there. No, we're not going there. Okay, then rethink that position, because that's to me what you're signaling. I'm afraid that's what they're going to perceive. All right. So you should feel free to test people with your offers and your demands. That's the goal, is to test. All right. I think what you need to do is make sure your mediator, if you're going to do a last best final, is it a really we're leaving the room last best final, or is it a, okay, we want them to know we're kind of getting there, but don't let them leave. Okay, that kind of thing. So really be intentional in terms of, how you view this as always tapering, how you can do it, how you can get there. Bracketing is a way to do it. We don't have time to talk about bracketing. I wish we did, because I think it's very effective. But really, it is your client's decision. And you really have to keep that in mind. But I always tell the client, you have a right to know what the other side came to pay or what they'll settle for. And you should want to know that. Your attorney wants to know that. And in order to find that out, your attorney has to be strategic in the way they negotiate. So you as attorneys really need to be strategic, and you don't want to leave in a position that you don't like if the case doesn't settle, yet you need to show the other side that this case is within reach of settlement. So really be mindful of it and use your mediator. How do we get into this range? How do we get here?
Let me just follow up on, I'm sorry, Adam. Hopefully you've hired a mediator that you trust and who has good judgment. And I just want to follow up on Lauren's comment. Use that mediator, trust that mediator, make that mediator earn their living. It's what we do, every day now. And we've learned how to be persuasive and help get to the point you want to get to. Adam, I'm sorry for cutting you off.
Yeah, no problem. My advice on negotiation is I took a course that had a bigger impact on the value of my settlements in a favorable manner, more so than any law school course or continuing education course. And that was a business school course on negotiation. And I took the Harvard Business School online course for negotiations. It was like a 4-week deal. And I think it cost $1,500. I don't know the exact amount, even if it was $5,000. I went to a mediation 2 days later and I settled the case for $200,000 more than I know I would have settled the case, just because a part of the course was self-assessment things. And I learned some things about myself. I realized that I was capitulating at the end of settlements. I was getting towards the end and I was already above the number I wanted. And I was afraid the deal was going to go away. And so I just took it and ran. But when you're that close and you're getting closer, the deal's not going away. The other side wants to get it done just like you, things like that. And so I was hanging in there a little bit longer, and it led to settlement. So I highly, highly recommend taking a business school course on negotiations. There's UC Berkeley extensions. You can go in person. You can do these courses online. Highly recommend it. It will definitely pay dividends in your skills. And it's not just about negotiating numbers. You know, you learn some important things about, you know, just negotiation psychology and all of that. So highly recommend that.
So Tom, I think the last slide is agreements. Can you just say a quick word about that?
Sure. Read CCP section 664.6. I find it, if I'm litigating a case and we've gone through a long day, I'd like to have the parties sign an agreement that can be enforced if they wake up the next morning with buyer's remorse or seller's remorse. I have a form mediated agreement. I make it clear that I'm no longer paying E&O insurance as a lawyer, and therefore, you know, they're responsible for the language, but I make it easy for them. I get the basic terms in there. And nowadays, an attorney can sign it if they want to do that. But just, you know, read this deck, look at the terms, the basic terms, and think ahead of time what you need, what your client needs. Talk to your client about if they want confidentiality, why, what terms, etc. I think it's a really important thing that sometimes gets missed. It's an easy thing to get done in a day. On Zoom, you know, I can send things for DocuSign. It's not a problem. Happy to do it. And I believe that if you spend all day and you reach an agreement, get it in writing that can be enforced. Yeah. Lauren, Adam?
Well, I would add that an attorney can sign if they have express authorization to sign. Doesn't have to necessarily be in writing, but they have to be authorized. That's important, and I think that's new language. You know what you want the outcome to be. Bring a draft and have, what I mean is have one prepared, a draft settlement agreement. And hopefully you can say to the mediator, hey, use this one. And, you know, things may need to be tweaked, but hey, I have one prepared. Do it ahead of time, and don't, for these important things like, oh, just one more thing at the end, I need confidentiality. Well, that's huge for some people. And so you'll blow up an entire agreement. So the things you know you're going to need, in addition to a number, make it clear what your client's going to need. I need confidentiality, non-disparagement, you know, blah, 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 you know, cover the lien language, whatever. So really be mindful before you go, and know what you want to have in that agreement and prepare a draft of it. You could send it to the mediator ahead of time without the numbers filled in, but here are the basic terms I'm going to need, you know, and that way, A, it goes faster, and B, you make sure those important things are discussed as the mediation goes forward. So I will also say, if you're young lawyers, ask the partner on the case if you can go with her to the mediation and just sit there and observe. And any of you who want to observe a mediation, I can get permission from the other side, oftentimes from both sides, to have you shadow a mediation. You're welcome to do that, but I encourage you to get in and see what they're like. I guarantee once you mediate a case, you'll be better at handling the case and preparing for mediation.
That's the end. We kind of hurried through the last few decks, Adam, but anything to add and any questions to respond to?
No, people can still chime in, but thank you all for attending. This was great, part of this series. Really thankful to Lauren and Tom for their advice, their input, their reflections on the many years of doing mediation. We all know how important mediation is to the outcome of the case for our clients. And it's really good that you're here, because getting better at mediation is a very important skill for litigators in all areas of practice, because mediation comes up in all areas of practice. So thank you all for attending. I will volunteer Tom and Lauren to be available for your questions and answer your emails, but only if you
There's the
email them.
poodle.
Only if you, and the poodle, yes, but only if you email them or call them after 11 o'clock at night. That's the only time they will respond. No, you can reach out to them or me if you have any feedback questions, or if you have an upcoming mediation, you want to game plan with someone and talk it out. Be deliberate, think about this as it comes. Mediation is a very big day for your case. So thank you all.
Thank you
Thanks
all,
all.
everybody. Have a, let's see, turn off the recording. Yeah, it's all.